Thank you.
Thank you very much. So I want you to imagine that I'm a limited company, the Funky Shirt Company Limited, which will do. What are you?
Migraine-induced
Migraine
shirt sellers, I think.
Shirt sellers. Okay, so we're going to be talking about commercial debts, how you recover your commercial debts, what the difficulties and problems with recovery of commercial debts is. Litigation is a machine which you go into as a pig and come out as a sausage. Do not litigate if you can possibly avoid it. Kent's sitting there. Where is he? Yes, he heads up a part in our litigation department. But he always says, if you want to litigate, don't. There's a lot of cost, a lot of trauma, a lot of disappointment, and you have to meet your lawyers a bit more often than you'd perhaps like to. So we need to look at, first of all, alternative dispute resolution. This will be encouraged later on if you do litigate, so it's really good to do it at the beginning. Do it now. What's alternative dispute resolution? That's talking. So it's discussion. It's seeing whether you can mediate problems, seeing whether you can discuss things out, talk about the issues that are arising, the problems that you've hit with the person you're trying to recover the money from. Do it now. It's a good incentive to do it now because you will save costs and you'll probably save your business relationship as well, which is really, really key. Remember, if you're having discussions with anyone about debt, you might want to make it without prejudice. So this is a legal term that protects discussions where you're negotiating a disputed debt. So if you're having a phone call with someone and you think there are contentious issues, you might want to say, can we just talk off the record without prejudice? Make a note of that. Really, really important, because you don't want to be pulled up on what you've discussed with them a bit later on. And that can be used in evidence, that telephone conversation. So if you make it without prejudice, then you've got that protection. Sorry, over to you.
So Adrian's company has come to talk to me about a debt apparently I owe him. The first thing I need to consider is, should I talk to him at all? Now, this may depend upon my attitude as a company director, my past experience of litigation. Have I had numerous companies in financial difficulties? Or maybe this is my first attempt and I'm really proud of this company and I want to make sure it succeeds. So these factors may play in my mind as a company director as to whether I'm going to deal with this. What's the company's financial position? Can I afford to pay this amount I owe him? Or am I in financial difficulty? Is this a valuable business relationship? I don't know. I'm not sure about this one. But do I want any further business from him? Well, if my company's in financial difficulty, maybe I don't. Maybe I can just sacrifice him. What about my reputation? Will I suffer reputational damage in the business environment if I don't pay this debt? These things do get out. Talking. Now, he's asked me to talk to him. Should I do so? Well, from the company's point of view, if I do, we could get this matter resolved and it could avoid legal action. And legal action means legal costs. So this could be the better option to talk. But do I need to consider any issues before I do talk to him? Have I made any payments to him? He tells me that I owe him £50,000. I can't remember that. I haven't seen any proof. I'm sure I made a payment to him. Hang on, I've got a counterclaim against him. He owes me money. Will that extinguish the debt? These are the factors you need to look at before you enter into any correspondence with him or any form of negotiation.
So the negotiations are broken down. So step one is to send a letter before action. This is a kind of key document that you do need to pay good attention to. The reason you have to do that is because if you litigate later, if you have not sent pre-action correspondence, you're going to be in difficulty, probably, in recovering your costs. In commercial debt cases, it's not quite so crucial as where you're recovering on an individual basis, but it's good practice in commercial disputes to send a letter before action. And what do you need to do in that letter before action? Well, as Michael said, what is this debt for 50 grand? Where's your documentation? Hunt it out. Get your documentation in order. Make sure everything is set out there. You can prove your debt. Make sure you know who did the deal on behalf of your company if it's not you. Make sure you know who you're dealing with. Is it a limited company you're dealing with? Do some searches. Look at your records. See who you're actually dealing with. Is it an individual or is it a limited company? These things are really, really key. Another key thing to consider is, how old is this debt? If your debt is over 6 years old, you might be difficulty recovering it at all because you may be barred by reason of statute. So you need to think about those things, and this is the time to do it before you get things underway, because once you start in litigation, you've got a problem discontinuing litigation. So think about it now. The letter before action, really, really important key time for you to sit down and assess what this is all about, who you're trying to recover your money from. One thing you might want to consider as well in your letter before action is the recovery of interest and recovery of statutory sums. So if you have terms of business which set out rates of interest that are due on outstanding debts, you can use that as your claim for interest. If you don't have terms and conditions that cover those things off, then it's perfectly okay for you to claim statutory interest under commercial debt provisions. Statutory interest is 8% plus the bank base rate, so 8.75% at current day rates. And also, in a debt of, say, £50,000, you can claim a lump sum of £100 on top of the debt. It's a small amount, but you can put that in your letter before action and recover that on top of the debt as well. So you send your letter before action, make sure it goes to the right person on the other side.
Miraculously, it's arrived at my desk, and I look at it. First thing I need to do is look at the dates, look at any deadlines within that letter. That letter will normally provide me with a set number of days to pay the debt or to dispute it. So diarise that. How long do you have to respond or pay? That's one of the crucial things to look at. The next thing, look at the figures being claimed. Is that the debt figure? Is the amount requested in late payment charges correct? How about the interest? Do you want to do that calculation as well to make sure those figures are correct? Once you've got that letter, again, look back to see whether you've got any counterclaims or any other claims at all which could extinguish this debt. If you do want to settle this, then you should do so quickly, and that's going to stop the interest and these charges and costs building up. Can you negotiate the letter before action? Well, it says a certain sum, but perhaps you can put forward an offer just for the initial debt sum alone. Forget the interest costs and late payment charges, just go for the initial debt. You may find that his company will take that. They'd rather take that than all the other little bits which go on top of it as well. Is being an ostrich helpful? Lovely slide here. Should you be burying your head in the sand? No, not really. It's not going to deal with this matter. It's unlikely to go away. You could ignore the letter before action and the claim with it, but all that's going to happen is the claim is going to carry on running up legal costs. And if they issue proceedings, the risk is that you're going to have to pay those at the end of the day. So it's not to your advantage to do so. You may think, well, if I ignore it, I'm just going to test the claimant, let them see what appetite they have to litigate. Let's see how much money they've got. Drain away their money by just letting them chase me, and I won't respond. You can do that. It's a high-risk strategy. If you know what you're doing, if you have some information about the claimant company, if you think he hasn't really got that much in the way of assets, maybe let him do that. Waste his money on litigation. But again, it's high risk. You could just delay and delay responding. But again, that also runs the risk of costs being built up. If you do delay or don't respond at all, then the risk is that he's just going to issue proceedings on me, and I'm going to be faced with a court claim with further costs on top of that. So all that's happening by delaying this is that the figures are building up and up and up. Much of this, though, depends upon the financial state of the company. If I'm in financial difficulties, then maybe this is just another letter before action, which I just add to a pile, growing pile of them. Over to you.
Yeah, so impecuniosity of the defendant. So you need to be considering, you should have perhaps considered it when you were looking at your letter before action, but now you really, really need to consider it. If you're going to take this matter forward, if Michael's company is not responding in a favourable way, you need to think about whether you're really going to take this forward. Do your searches at Companies House if you haven't done them already. Carry out some tracing inquiries. Use a local bailiff to undertake some asset assessments if you can do that. Look at your own records that you hold on this company. Have you got bank account details? Need to be careful about GDPR, of course. But look at what data you already hold for these people. Have they got a history? Have you had debts recovered from them before? Have you used lawyers in recovery of debts? How successful was that? It may be that someone else in your organisation has had a go at these people before and won or lost, but this might be a good indicator for what's going to happen now. Look at property. Office copy entries, if you think that the company owns property, carry out some office copy entry searches, have a look at who the legal owners for those properties are. And then you've got some choices, haven't you? You can either drop it or you can crack on. We'll be talking about court claims in a moment. There's one thing you might want to consider at this stage, and that is a statutory demand. Anybody dealt with a statutory demand before? People know what they are. This is not litigation. These are provisions that are set up under the insolvency legislation, basically a form that you serve on a limited company or an individual. In the case of a commercial debt, the limited company that you're intending to recover money from only needs to owe you £750. In an individual case, it's £5,000. But if you're owed £750, as I am in this case, I can serve a statutory demand on Michael's company. There's no fee to do that. It's a preparation of a form. So what I have to do is to get that form ready and then serve it on Michael's company by a registered office, by registered post, or personally on one of the directors of the company. Personal service is ideal, and it really, really upsets them. So it's a really good idea to do that if you possibly can. Get a bailiff to serve it if you're uncomfortable about doing it yourself. You can only serve a statutory demand, though, if the debt is not in dispute. So all your preliminary work on what's this about, who owes me the money, is there a counterclaim, as Michael's mentioned. If you've got a counterclaim there floating about, forget a statutory demand. You need to go to one of the other options. But if you've got a straightforward debt claim, and maybe he's admitted it, yeah, we owe you the money, but we just, can't afford it at the moment. Statutory demand, bang in there with that, serve it. He's got to deal with it in 21 days. If he doesn't deal with it in 21 days, the statutory demand says that you may well present a petition to liquidate that company. Now, that may be a problem for Michael.
Bit embarrassing. This person turned up at the door, statutory demand, and gave it to the receptionist for the whole building I work in. That's bad. My reputation is going to get damaged by this. But what options do I have as a company? Well, this depends really upon whether I dispute or I agree with this debt. I could just pay the sum demanded, or I could pick up the phone and try and negotiate a reduced or deferred payment. The other alternative is I could oppose this, but that means going to court, paying lawyers' costs. I don't really want to do that. So, if the company ignores the statutory demand, what happens? 3 weeks go by. I've done nothing about it. The company is then deemed to be unable to pay its debts. He can then present a petition to wind up my company. Now, once that petition goes to court, this is a very public event. It's a public method of enforcing a debt. Once the petition's filed at court, notices get put in the press. Now that means other companies are going to hear about my trade, and they're going to see what's happened. That could draw other claims out of the woodwork as well, and suddenly I may be hit by other demands, and I don't really want that. So a petition can affect the future of my company's trade, and even if it fails, then my reputation is going to be damaged by this. So I have to bear that in mind. If I accept that his debt's payable, then the best thing to do is that I need to contact him as soon as possible and arrange to pay the debt. Now, if I've agreed to pay the debt, what guarantee do I have that he's still not going to proceed to court? Well, what I really want to do is get a written undertaking from him or some form of agreement that he's not going to proceed with any petition. And then hopefully that will protect my position. If I can't pay all the debt at once, then maybe the other thing I need to do is to talk to him to see whether he's willing to accept a reduced payment or deferred payment or some type of payment plan. Now, the practical advantage for him is that he'll be getting something out of my company rather than nothing at all. If he goes to court and winds up the company, he may see nothing at all. Or he may just be ranked as an unsecured creditor in any insolvency process. He may only get about 1 pence in a pound. So perhaps something from me now is better than nothing at all, or minimum amounts later on.
So now you're thinking, oh, cripes, do I need a lawyer now? You may well need a lawyer now, because he's probably not going to pay on this statutory demand. What are you going to do now? So options available to you, county court or high court. Where are you going to do it? You're going to do it online? Do you know what you're doing? You might need to seek some specialist advice at this point. So a claim of £50,000, you can commence that in the county court, these days. That will progress on what we call the multi-track in the county court. So judges take a very hands-on approach to litigation these days. They tell you what to do, when to do it, and you better do it. If you don't comply with time frames, that's a big problem for you these days. In the old days, when we used to do it in the old days, it didn't matter very much. You went along and smiled to the judge and he was quite happy. Now, not so. They're irascible, they are unpredictable. It is a bit like chucking a dice around. So you probably need to get some help at this stage. You can issue your claim on your own, it's not a problem. There's an online portal for issuing claims these days, but you've got to get your paperwork right, and you might want to think about that carefully, especially if you've now got the issue of perhaps a counterclaim, an offset in respect of your claim, how's the evidence looking for you, and so on and so forth. How fast is it going to go? Well, nothing goes very fast in the county courts. They're really, really understaffed. The judges have loads of box work. They'd rather go and play cricket and golf and this kind of thing. So things don't get dealt with very, very quickly. The other thing you need to know is even if you've issued a claim, the court at some stage is going to say to you, come on guys, why don't you talk about this? We don't really want to see you in court. We haven't got time. We'd rather be out playing golf or playing cricket. So it brings us right back to where we started. Discussion, negotiation, mediation. Perhaps you need to take a bit of a hit on this debt early doors so that you can get the money in the bank and not have to worry about all this nonsense. What's it going to cost you? Shed loads of money. 30 grand, Kent, on an average multi-track case? £30,000. And if you lose, you're paying his 30 grand as well. So all of a sudden your 50 grand case has cost you an awful lot of money. So you need to think about that very carefully. Lawyers, unfortunately, work on an hourly rate these days. So it means that all that time you take up with your lawyer is costing you money. And when he's off seeing his lawyer, exactly the same thing is happening. And who pays those costs? Well, you do. If he doesn't pay, if he goes impecunious and he goes bust at some stage, you're still paying your lawyer and you've still got the debt.
He has now served proceedings on me. I get a pack in the post with a claim form and a whole document called a particulars claim setting out what his claim against me is. Now, Adrian alluded to the problems with the court at the moment. The courts are very unstaffed, as he said. They've got poor resources, and this means that they spend a long time trying to process their paperwork. It can take about 5 weeks to get a claim sent out. By the time you eventually get your claim served on you, the first thing you need to do is check those dates, because it could have been delayed, and you may suddenly find that you've got to get something filed in court by the next day. So check the dates very carefully. You have 14 days in which to acknowledge the claim, and you do so by a slip called an acknowledgement of service. That's basically a holding position, saying, yes, I'm defending the claim, but give me time to put together my defence. The acknowledgement of service buys you 14 days to then think about your defence, whether you're going to defend this or not, and then to enter a defence. This may be the time where you need to go to a lawyer. If you don't enter a defence in the court, then the court will be invited to enter a default judgment against you. So if I ignore it totally, don't do a defence, don't do anything at all, he can say to the court, I want default judgment because he hasn't put in a defence. Once he's got that piece of paper, he can then enforce with that piece of paper, and I don't want that. I've lost my ability to now argue about his case. If the matter is defended, then the next stage is the court will send out what's called a directions questionnaire, asking both parties to come up with a list of directions leading to a contested hearing. Now, in a multi-track matter, in other words, one where the value is £50,000 or so, there are a set number of directions which the court will expect you to go through, and you do need to have a lawyer to advise you on those points as well. The directions should also include an opportunity to discuss and to negotiate a settlement. I could say to him, look, I think we can deal with this. Can I have a stay in proceedings for, say, 1 month? And during that month, can we negotiate and see what we can do? If we don't get anywhere after that month, let's get back on board with the court directions and head towards a trial. So the court will encourage that, and they'll want to see that being done. From a cost point of view, it would benefit you to negotiate. You need to consider negotiations at all stages. You need to be making offers to each other. The court will expect to see you making offers to each other. If you make offers If I make him an offer and he accepts it, suddenly our legal costs have been completely reduced and they've been stopped. So again, it's in your best interest to do so. However, if I've decided I don't owe him any money at all, or I only owe him part of the money, then the best tactic from the company's point of view is to put in a robust defence, denying claims, producing evidence to the contrary, and once I've served that on him and he's seen my argument, then I'll go in with an offer, and it will be a lesser offer, but at least he'll understand where I'm coming from with that offer, and that's a good tactic to have.
Why the devil? Michael's mentioned an offer. What can happen at this stage, what can happen at any stage up to now, is that someone can make what's called a Part 36 offer. And this is like a bonded offer, if you like, which the court does not get to see until the outcome of the case, if the case does not settle. But the Part 36 offer says, I will settle for this amount of money, and if you don't accept these terms and the matter goes to trial and I do better than the offer that I've made to you today, then I will be wanting enhanced costs, enhanced interest on either the claim or the costs of the defendant. It can be a very, very, very expensive and dispiriting experience to find that you have failed to beat a Part 36 offer. If you are claiming a debt, it is very, very good practice to make a Part 36 offer in the early stages. You can do it at letter before action stage if you want to. You can make an offer to the other side on a Part 36 basis, and it has to be very specifically drawn, so again you might need some help with that. But if you make that offer at that stage, you're giving yourself maximum protection. Why you're not doing it? You must be making offers. And as I said, the courts encourage it all the time, right throughout the process. Whatever the level of debt, you'll be encouraged to negotiate and think about discussing and ironing out these creases. Part 36 offer is crucial. If you're on the receiving end of a Part 36 offer, then you need to react to it. Very important that you do that. And very often a Part 36 offer will be for a fixed time frame, generally 21 days. And if you haven't accepted it in that time, it may not be capable of acceptance. You could accept it later, but it may not be capable of acceptance. It may have what's called a sunset clause in it, which means that it drops out the picture at a specific given future date. So you need to look at that very carefully.
I've received a Part 36 offer. I need to look at the figures involved. Has he discounted some down at all, or is he still asking for exactly the same figure as before? Is it attractive to me? Is there any risk to me? Do I have 21 days to accept this, or a lesser period of time? From my point of view, the same applies. I can make offers back to him. I can put him at risk. I can look at my finances and I can tell him, look, I've only got this much, and therefore I'm going to make you an offer of £20,000 because that's all I've got. Now, that could be a reasonable and realistic offer. And the thing about Part 36 offers is they have to be reasonable and realistic. They can't just be any old figure. You've got to have some basis behind it. And if he can understand where I'm coming from, he may accept my offer. But if he doesn't, and we go to a contested hearing, the judge may understand where I was coming from at that time and making the offer. And he may look at it and say, well, why didn't you accept that offer? You could see that at that time he only had that much money. That was a reasonable offer to make, and it could have avoided all of this litigation. So there is a risk to both sides with Part 36 offers, and they're designed to be a great weapon in the armoury of any litigator to use.
We talked a bit about the possible impecuniosity of the defendant, but what about your impecuniosity as a claimant? Does that make any difference? Does it matter? Well, yes, it does. Because Michael is able to say to me, if I'm progressing a claim as a claimant, I've got reason to believe that if this matter goes on to trial, you would be unable to pay my costs if you lose this claim. And in those circumstances, Michael can ask the court to make what's called a security for costs order. So there you are, you're stumped up with your 50 grand claim, and you've looked at whether he's able to pay that debt or not. You're sitting there with a negative bank balance or illiquid assets. And then he comes along and says to the court, hang on a minute, chaps, if I win this and I am able to defend this claim, who's going to pay my costs? Because we've already discussed These could be a very large sum of money. And the court can well step in and say, yep, you're absolutely right. So the Terrible Shirt Company Limited has actually got to put into court £30,000. So now I've got a debt claim of 50 grand and I've got to stump up 30 grand for his possible costs in the event that he successfully resists my claim. So this can stop your claim in its tracks. If you haven't got that money, your claim stops dead. You will not be able to take it forward any further. So you need to think right at the very beginning, and you know where this is going, everything's front loaded. You need to think right at the start, what if I face this? Have I got the money to litigate? Because it's an expensive process. So let's assume that I've progressed this claim now and I've got a successful judgment against Michael. It might have taken us 18 months to get to trial. We've had a fight in court and he's lost. Hurrah. I've got my judgment in my hand. Now what? What am I going to do? Remember the statutory demand? I can serve one again now. So I can serve a statutory demand based on a debt, on a judgment that I've actually got. He can't resist it because the case is dealt with. So I've got my county court judgment and I can use that against him. So what's he going to do then? He's got to raise the money, or there's a risk that I'm going to petition for the liquidation of his company. That might not be something he wants, and he might actually find the money by fair means or foul. What else might I do? I might send county court bailiffs round. We've got a bailiff in the room, haven't we? Yes, there we are, okay. I won't say anything nasty about county court bailiffs, but you're not a county court bailiff, so that's okay. Okay, so county court bailiffs are really, really not that good. Okay, so what you want to do... I agree. Yeah, okay, perfect. So what you'll want to do, if you've got a debt, say, let's say we've succeeded 50 grand or whatever it might be, you want to transfer this debt up to the High Court. If you transfer it up to the High Court, then you can get the High Court bailiffs or sheriffs to execute that. They're much, much better. They're much more aggressive. They don't take any nonsense. They're going to get in there and kick someone's butt. So that's what you want to do if you want to go with the bailiff route. So what are bailiffs and sheriffs going to be doing? They're going to be seizing assets. Has he got any assets? You know, where's his business premises? Has he just got a little, you know, a place at a hotel that he just works out of? Has he actually got any assets? Has he got any cars? Are the cars on leasing plans? Well, they don't belong to him if they're on leasing plans. Does his wife own all the assets of the business? You know, these are things that, again, you perhaps should have thought of right at the beginning. Maybe a bit too late to be thinking about it now. So you've got your judgment, you've won the battle. Are you going to win the war and actually get your money back? This is kind of key. And again, you need to be thinking about this at the front end. Thinking about securing charging orders on property so you can get a charge, a mortgage on any property that's owned by the company, and then you can enforce that. You can say to the court, okay, I've got a charge, I'm effectively holding that asset and I want my money, so I want you to order that asset to be sold so that I can have my money back. It is possible for you to do that. One thing that we like to do is also examination of a judgment debtor. So what we can do, if we don't know enough about this particular company, we can actually ask one of the officers of the company to come to court and tell us about the assets of the company. So even though these things might be concealed, hidden, not available at the company's house, or we haven't been able to get the information by looking at assets pre-action, we can actually ask directors of the company to come to court with their books. They don't like that very much. I'm now going to have to show you what I've got. An examination of the severest kind, I think one of the case laws said. So you can really get stuck in there. You find out what they've got. What is this car? Who owns this? What about this bank account? Have you got anything else? It's all under oath. So they have to give truthful information. And these applications can be made to the court after judgment. I always like to serve them on financial directors because they absolutely hate it. They absolutely detest it. And very often you can go and serve it on them. I've done it once at their personal address on a Saturday evening as they were going out for an evening. They absolutely, it was terrible. It was abusive and nasty. But we got paid, and it's really, really important. Remember what you're trying to achieve. You're trying to get payment out of these people. Very often they're just going to sit there unless you take proactive steps to actually get them to pay. And making an application for examination of a judgment debtor is a really, really good thing for you to do. It will give you information that you need to take the recovery forward, but more often than not, a judgment debtor is going to say, okay, we're done. Let's pay. Yeah, I think that's right. So the court will order an officer of the company to appear at the examination. It's on oath, as I've said, and if the company has been acting in a particularly difficult way, then I can ask for the examination to be undertaken by a judge in open court rather than by an officer of the court, which is typical. And again, that can be a fairly daunting experience for a judgment debtor.
Well, the court sends me out an appointment. I've got to turn up to court with all my books and to answer questions under oath. Now, I think I've done this before, the type of company I run. I've had financial difficulties in the past. I went along, sat in front of a court official who didn't really have enough time to talk to me, ran through a list of questions. I gave very short answers. He just said, yeah, that's fine. And that was it. But the prospect of being in front of a judge may be a bit more worrying because the judge will drill down into the books and ask for figures. So there is that risk there. If the officer of a company fails to attend the date for questioning, then the court has the power to order that officer to be arrested. So they can literally be arrested and then dragged before the court, and then they have to answer the questions. There's always the risk they can get sent to prison as well for their behaviour. So if you do get that appointment from the court, you should look at that seriously and attend. The company could also advance a proposal for payment during the hearing. So again, that could go forward, but the creditor may listen to that proposal and decide to reject it. If that proposal is rejected, then the court may decide to list the matter for a further hearing at a later date to decide whether it's a reasonable offer or not. So this whole process could still be dragged on, and the more things get dragged on, the more legal costs are incurred. I'm going to very briefly touch on insolvency, but the main point is, as a company director, if my company is in difficulty, I go and see someone like this. I go and see an insolvency practitioner. So that's the main point. There are a couple of points I just want to make on insolvency. I'm not going to go into it in depth, but from his point of view, he can send a High Court enforcement officer after me, but every day he's going to be looking in company's house to see what the status is of my company. If my company becomes insolvent during the enforcement proceedings, then he's not going to get his money. Unsecured creditors are unlikely to get back the full amount of their judgment debt. So, is it even worth him trying to enforce against me? Is he only going to be wasting time and money by doing so? So he has to ask that question. There are other problems in pursuing my company if it's going into liquidation. For a start, if it goes into liquidation, you can't commence or pursue an action without the court's permission. If it goes into administration, any litigation is automatically stayed, and again you need the administrator's consent or the court's permission to continue that litigation, and that consent is only granted in limited circumstances. One thing though, does my company have any insurance? He may look at my company. If there's an insurance policy which would cover his liability, he could potentially enforce against that policy and be able to make a claim. The last thing I just want to touch on are preferential payments. So once I'm aware that my company is insolvent or there are warning signs that it's going to be in financial difficulties, one of the director's responsibilities is to maximise the financial return to creditors. If I decide to make a preferential payment, in other words, I'm going to use company funds to pay off his debt, but I can't pay off all the other debts, then that's a serious breach of my duties as a director. And the court can also order him to pay that money back, which I've just given him to satisfy his debt, to the insolvent company.
So a bit of a whistle-stop tour of a commercial debt. So access to justice these days is a lot harder than it used to be, I think. There are very strict rules now about compliance with time limits and those kinds of things that I mentioned before. Getting court dates is much harder than it used to be. We used to have a lot of judges who were able to adjudicate on these things quite frequently, but now in a multi-track case, a 50 grand case, you only have fixed windows for these trials once or twice or three times a year. So very few opportunities to actually get your cases dealt with. So access to justice is much, much harder. But claims can be won. That's what the smiley face is about. Occasionally you can get a good outcome, but it is hard fought. But you've got to look at all the weapons that you've got in your armoury, use them all, remembering that you can use lots of things at once. You don't have to go down one route and then think, oh, let's try another route now. You can sort of multifacet with those things. So hopefully that's been helpful to you. We do a series at So Legal. We have a series of briefing notes on some of these litigation topics. So Part 36 offers on limitations. So when you can commence your action and when you're prevented from commencing your action, and particularly on costs, which is probably, I would say, the most or the least understood area of what we do. Most people know about their debts, they know about things about limited companies, but costs, I mean, it blows our mind a lot of the time, doesn't it? But for people who are listening to us, it's a very, very difficult topic to get your head around. But we've got some briefing notes that can hopefully help you understand that. Hope very much you've enjoyed that, and we'll look forward to listening to our other speakers. Thank you.